Council ready?
Yes. We won't need to take things.
Good thing you left.
All rise, please. Yes.
My Lord, before the lunch adjournment, I was dealing with the issue of demonstrating, or the claimant's ability to demonstrate the irrationality of the decision. And that before I take you through the various themes, just to re-clarify the point, my Lord, it's not simply that we say that the decision was irrational or perverse, but also we rely on Article 57 of the contract law to say that there was bad faith or not fair dealing, or that it was unreasonable. I'm referring to the contract law, my Lord, for the decision to be made. And over the lunch adjournment, I was looking at Braganza again, and if I may very quickly, my Lord, take you to that again. So that's behind the Defendant's Authority Bundle, in particular page 183, and you've already read this paragraph, which is paragraph 22. I invited you to read that, as well as paragraph 23. And paragraph 23, in fact, is something that I want to go back to, because what Baroness Hale says, referring to the decision of Lord Sumption in Hayes, rationality is not the same as reasonableness. Reasonableness is an external objective standard applied to the outcome of a person's thoughts or intentions. The test of rationality, by comparison, applies a minimum objective standard to the relevant person's mental processes. Why am I then taking you to this again, my Lord? The reason is this. The claimant's claim is pursued on two premises. The first one is that the decision was in breach of Article 57 of the contract law, in particular 57B, C and D. D talks about reasonableness, and we say therefore that the decision, or the consideration of the decision for eligibility, wasn't reasonable. The second premise upon which the claimant's claim is pursued, that the decision was irrational. Then, my Lord, just before I go through again the themes, if I can ask you to turn to paragraph 29. I didn't take you to this part of the judgment before.
Yeah.
If it is part of a rational decision-making process to exclude extraneous considerations, it is, in my view, also part of a rational decision-making process to take into account those considerations which are obviously relevant to the decision in question. And my Lord, again, when I follow through with the themes, when going through the documents, we say not only is there no evidence as to why Mr. Winters reached the decision he did, but in fact he failed to take into account relevant considerations as well, and hopefully that will bear out on the documents. So the first theme that I was taking you to before the lunch adjournment was the decision, the changes rather in the decision, or the reasons as to the decision. And we looked at PK Madaka's call on the 9th of March, the email of Bill Winters on the 17th of March. If I can then invite you to look at page 22 in the sheet of papers that I provided to you this morning.
22.
Please.
Yeah.
So this is the email from the claimant. Again, he reiterates the reasons that were provided to him by PK Madaka. PK Madaka is copied into this email. There's no email or documentary evidence at this point to contradict what the claimant is saying. And so, my Lord, this goes to the point that clearly there are issues of fact here that can only be decided on evidence and disclosure. Page 23, this is Mr. Papadopoulos' note of a conversation that took place between Bill Winters and the claimant on the 31st of March 2016. Under key matters discussed, the second paragraph, Mr. Papadopoulos records, BW said that the rating was based on a very thorough review by Tracy Clark and PK Madaka and was supported by incidents and dates, etc. If this is correct, and Mr. Winters did say that, then it's not sufficient to say that Mr. Bill Winters was entitled to make the decision. On the basis that there's a positive admission on the claimant's case that Tracy Clark and Madaka did a thorough investigation, then that investigation needs to be in front of the court for the court to establish whether or not the decision connects to the evidence. We're not seeking for the court to embark on an intense scrutiny of what was before the bank, but simply to review matters and see whether or not the decision reached was logical based on the evidence that the bank had before it at that particular time, and we say that that's within the ambit of the law and what, in fact, Braganza provides for. Then, my Lord, still keeping on page 23, under key matters discussed, first, second, third, fourth paragraph, where Mr. Papadopoulos records, Bill said that the D rating was based on a pattern of behaviour and also on other issues such as instances of personal financial dealings by staff indicative of culture issue in UAE. He said that the D rating was a judgment call. Again, my Lord, this is in order for it to be, or rather put differently, a judgment call doesn't tell us how Mr. Winters assesses performance rating against any guidance, any measure of performance. And if anything, my Lord, it goes to the point that I'm making, is that this was absent any logical review of anything, and would imply, or rather the court could be minded to draw an inference that in fact that reference to just a judgment call amounts to an arbitrary decision. Again, something that would probably need to be tested against the evidence at trial. And finally, just on this point, page 24, I think I've already referred you to this email, my Lord. It's the email of Neil Cuthbertson, 1st of April 2016. We would invite the court to draw an inference that, in fact, at the time that Mr. Winters reached his decision, there was no evidence substantiating the D rating, and it was only after the event that the bank wanted to put together reasons for the decision, which is what we say, the inference one can draw from this email of Neil Cuthbertson. So that's in terms of the changes of the decision. And then finally, I beg your pardon, page 32, which is the decision outcome from the grievance. Summary and approach. As part of Annie's review Anna, which was the grievance investigator, interviewed the following individuals. These have never been disclosed to the claimant and therefore again invite the issue of there being a serious dispute in fact. Point 2, consider the following documents. More or less we don't have a copy of those documents and therefore that's something that could only be tested at trial. But the decision making, page 33. In here we say that not only further reasons are provided for the derating than first given by Bill Winters on the 17th of March, but those reasons that Mr. Bill Winters said on the 17th of March weren't the basis behind the derating are then resurrected. So, for instance, the Bahrain issue, we see that there at the second bullet point. And so we say the changing of why the derating was given over time indicates, and we would of course invite the court to draw an inference, that there was no real reason, and therefore the inference is that this was, or the decision itself was made unreasonably, in bad faith, not in fair dealing terms, and also there is an element of irrationality to it given that the evidence leading to this isn't cogent. In fact, it is non-existent. So that's the first theme in terms of changes of the decision. The second theme that the claimant relies on in terms of the court drawing an inference of bad faith and reasonableness is the way in which the grievance was handled. Of course, we accept that that's not a freestanding claim in itself, but it's merely part of the evidential factual matrix upon which the claimant relies to invite the court to draw an inference of bad faith. If I can first invite you to turn to page 25. This is an email at the bottom from Pamela Walkden, the grievance investigator. I spoke to Bill today. Bill has agreed that we do not negotiate on money, but we do a limited review of values rating. This should not be a full review of Bill's judgment upon the values, but should assess whether there was a broad section of views taken into account and not what Christos considers to be a biased view from investigations. My Lord, can I just invite you to keep page 25 open and go back to the application bundle and turn at page 70, please. This is the grievance policy that's attached to the particulars of claim.
Did you say 70?
70.
Yeah.
And clause 2.2 of this policy is the last sentence starting, where the complaint is against the individual's immediate manager, the investigation should be carried out by an independent and, where applicable, practicable, more senior grievance representative. I can't confirm whether or not Bill Winters was Pamela Walkden's line manager, but we can certainly confirm that Mr. Bill Winters was more senior to Pamela Walkden, and therefore, in accordance with our own policy, Pamela ought not to have been appointed as a grievance investigator. And furthermore, page 25, the email also demonstrates the lack of independence and impartiality. Given Bill Winters was talking to Pamela and really navigating the approach that she should take in this grievance process. Page 26. This is an email from the claimant to the grievance investigator and Bill Winters on the 12th of April. And what he says in the third paragraph, in summary, what I hope we are all trying to achieve here is to examine the veracity of the allegations concerning my management style allegedly made by a number of staff. And then he sets out the approach that he thinks ought to be taken. Number one, review my past record. 2, interview my line manager, 3, interview my direct reports, 4, interview the staff who raised the actual allegations. And this goes back to the territory at paragraph 29 of Braganza, whereby Baroness Hale referred to considerations that ought to be taken into account, and clearly these were considerations that ought to have been taken into account and weren't. At the bottom of page 26, based on my past experience of similar investigations undertaken by CB, also best practice, minutes should be taken of all interviews. The interviewees should be asked to confirm the minutes of their interviews for factual accuracy. Agreed minutes of interviews should be shared with me on a timely basis. None of this, in fact, happened, even though, my Lord, if one turns to page 28, the bank confirmed with Mr. Papadopoulos that the grievance will be conducted in accordance with the bank's usual process. That usual process, which is in the grievance policy at page 70. But we say it wasn't undertaken in the usual, in accordance with the usual process. If one turns to page 71, which is the second page of the grievance policy, paragraph 2.6, the employee should have a right to appeal the decision within a reasonable time frame. The appeal decision will be final. Mr. Papadopoulos wasn't given an opportunity to appeal the decision or the 12th of May outcome letter. Paragraph 3.1.
So that's an appeal against what?
Appeal against the outcome of the grievance.
Right.
And the outcome of the grievance is committed to the decision letter dated the 12th of May that you've already been taken to. At page 32 of the papers that I passed this morning to you.
Yeah.
Page 71, back to the grievance policy. Paragraph 3.1, employees who have raised a grievance will usually be invited to a grievance hearing to discuss their concerns. The claimant was never invited to a grievance hearing. Paragraph 3.3. Documentary records should be made of formal hearings and a note taker may attend where appropriate. Well, the claimant was never furnished with any sort of documentary record, even though Miss Walkden in her letter of the 12th of May said that she spoke to various individuals. Paragraph 3.4 over the page, 72 of the grievance policy. Employees should have the right to present their case and to be accompanied by a work colleague. We say that the claimant never had a right to present his case because there was never any hearing. And more importantly, my Lord, 3.6, read with paragraph 4. Any notes of conversations with employees obtained as part of the grievance process will be treated as confidential. Fair enough. However, in certain circumstances, it may be necessary to disclose witness statements and or witness identities. No witness statements were disclosed. Furthermore, paragraph 4, formal hearings and other relevant evidence gathered as part of the grievance process should be documented. The mere fact that nothing has ever been disclosed to the claimant, we say, in breach of the grievance policy, creates an inference of bad faith, irrationality and unreasonableness. Particularly where the bank confirmed that this was the policy that was going to be in play when assessing the grievance. Just sticking with the grievance, my Lord, can I ask you in the application bundle again to turn at page 44? This is a note of the conversation on the 11th of May 2016. I see it's dated 2015, but that's in fact incorrect. It should be 2016. And even the defendant accepts that there was a telephone call and a conversation on that call between the claimant and Miss Walkden on the 11th of May 2016. And what this really goes to, my Lord, is that the claimant says he never had a grievance hearing, and in fact, the decision was already made on the 11th of May, which was one day before the grievance outcome letter of the 12th of May, despite there being no opportunity to the claimant to either present his case, to call for further evidence, or to have an opportunity to respond to any of the allegations that the bank was making.
So we don't have Appendix A.
No.
Okay.
And the final theme in this sort of category of submission, my Lord, is the bad faith argument when the settlement agreement was being negotiated. And my Lord, I go back to the sheet of papers that were provided to you in the morning. The first page is page 9, which is an email from Neil Cuthbertson, who's the head executive compensation human resources department of the bank, to PK Madaka, who was negotiating the agreement. And it's the second paragraph of that email at the top of the page, my Lord. Staying on the page, and this is discussing Christos and his calculations and his overall benefits. Staying on the payroll is fine for a few months if it helps the transition of permits, but it shouldn't be a protracted thing. In addition, there should be an offset of any extra earned income from staying on the payroll. Now, my Lord, the claimant has provided for this part of this email in his witness statement, which I won't take you to. But his evidence, in a nutshell, is that even at the point where negotiations were taking place of the settlement agreement, the defendant wasn't being entirely honest with the claimant. Page 10, my Lord. This is where there is a discussion about the terms of the settlement agreement. And again, Neil to Madapa, who's is the first, second, third paragraph where Neil is flagging up a few things. Third entry, the decision to make him TVC eligible, which I'm assuming is bonus, for the full year rather than the period when enrolled increases the potential value to him as well. And then the next sentence, the aggregate incremental value of a full year TVC and pension in pylon is worth US dollars 430k, see attached. We don't have the attachment. And then at the bottom, this is where Mr. Papadopoulos says it is pertinent. We do have the option to true up at the end of the year, of course. So when discussing the figures, they realised that this was going to be a big figure. However, what was said is that, well, let's agree, but we do have the option to true up at the end of the year. Now, that's the inference that the claimant is drawing from this email. Clearly, we don't yet have the benefit of disclosure or witness statements or testing of the evidence, but that's the inference the claimant draws at this stage. Page 11, which is the start of an email. At the bottom of the page, dated the 16th of August, goes over the page 12. Third paragraph from the top, I will concede the bonus piece given it seems so motive, although it is contrary to the approach we agreed on the redundancy policy, I know we'll end up at the right number. And again, I make the same point as the last email there. And finally, my Lord, if I can invite you to turn at page 14, it's an email from Neil to Madapa. It starts at the bottom of 13, over leaf 14. Second paragraph, unless I hear from you today, I will though arrange to include this, and that's annual club membership, so that we can move on, ... and on the basis that the cost of these exceptions will be factored into the year-end bonus decision-making process. And so, my Lord, we see there quite clearly there is no reference in the decision-making process, the year-end, there is no reference in the plan to take into account any payments that may have been made when coming to a termination settlement agreement. And again, same submission, it creates an inference. And so, my Lord, I'm going to leave it there in relation to the claimant's case as to Article 57 and irrationality, bearing in mind the points made in Braganza. My Lord, is there anything else that you'd like me to address you on in this part of my submission?
Yeah, that's very helpful. Thank you.
Turning then to, I think really it's the final application made by my learned friend, which is the application for a conditional order. Now, I say made by my learned friend, but in fact we've had no real submissions on this point, and we say that what the the applicant has to satisfy you of before you can even go to making a conditional order is that it's improbable for the claimant to succeed at trial. We say that he hasn't managed to do that, and therefore there should be no basis upon which a conditional order ought to be made. In any event, in exercising the discretion, the court has to be satisfied that the estate, in this case, can comply with a conditional order if made, and that it can raise the sum. And we say there's no evidence before you, nor should it be expected for the estate under these circumstances to meet any order for conditional payment. The risk of making such an order, we say, would stifle the claim, and it would deny the claimant's estate access to court, and therefore justice needs to be done. And therefore, my Lord, in conclusion, we say grasp the nettle and dismiss the applications, number one. Number two, the claimant the applicant has failed to surmount the high threshold or the high burden of proving to the court that the claimant's case is bound to fail. We say that the applicants are far from it. My Lord, I just want to pick up on one small point. It is a very minor point, and it kind of only take up literally 2 minutes of your time. I think you've been handed up the implied terms in contract and unfair terms law.
Yeah.
This goes back to the point we were making. So it's part 3 of the law, titled Unfair Terms.
What page you on?
Page 13 of the law. So this is the part that deals with unfair terms. And the claimant...
So this is part of the IFC Rule number 6, as opposed to...
Yes, the contract law.
Contract law.
Yes, that's correct.
Yeah.
So, my Lord, part 3 deals with unfair terms, and as pleaded, the claimant relies on Article 40 and 41,
Yeah.
which is page 15, and it was said that the claimant can't rely on Article 40 and 41 because the document that we are dealing with aren't written standard terms of business. And the reason that was put forward for that by my learned friend, as I understand, was because of Article 38, which talks about liability arising in contract. My Lord, having looked at this again, we say that Article 38 isn't relevant either to our case or to how Articles 40 and 41 should be read and interpreted. If one reads Article 38.1, it's this article applies as between contracting parties, where one of them deals on the other's written standard terms of business. So it only relates to this article, not to the law generally. And this is, of course, in relation to when one party is trying to enforce their rights against another party on the basis of standard terms of business. We say it's not applicable to Article 40.41. And in fact, we take support from Article 7, page 2 of this law. which provides for exceptions as to the applicability of this law. 7.2, this part does not apply to any contract so far as it relates to real estate, so far as it relates to formation and dissolution of body corporate and so forth, and obviously you can read on there. So, my Lord, the point is that the exceptions don't capture this sort of an agreement, and therefore we pursue our claim and say that it's correct to rely on Articles 40 and 41 for the construction of Clause 17. My Lord, unless there's any other issue you'd like me to address you on, my learned friend, Mr. Patrick Dillon Malone, wants to make a couple of points on the authorities. Very, very quickly, there's 2 points he wants to make, he tells me, and so therefore, unless, my Lord, I can address you and assist you with anything, I'm going to sit down and hand over the baton. Grateful, thank you.
Thank you, Judge. I'll be very, very quick. Just in relation to paragraphs 45 to 47 of our skeleton submission, we have relied on a number of authorities, and as you know, our case, this all relates to the construction of Articles 13 and 14 of the agreement. And we say that there are a number of principles that bear on the inherent improbability that the parties here intended to exclude from the right of enforcement breaches of the settlement agreement itself. And we've read the skeleton, and you see here a number of supporting principles in support of that proposition. We say that if breaches of this agreement, the settlement agreement, were to have been covered by Article 14, it ought to have been carved out. Ms. Ahmed has addressed you on that. I want to briefly then refer you to two cases in support of the passages from two cases in support of the propositions at 46 and 47 of the skeleton. First is the passage from Lord Justice Scotland, tab 13 of the claimant's authorities, tab 13. This was a case told against Associated Newspapers, judgment of Court of Appeal from 1933, arising from some colourful circumstances which we don't have time to get into, involving a liable background in the settlement agreement that had been entered into by Mr. Talbot and his company with the Daily Mail. And in this judgment, which is an authoritative statement, we relied on in textbooks and Chitty, etc., at page 644 of the judgment of Mr. Justice, Lord Justice Scotland, he emphasises the principle that in the case of future performance, where an agreement contains a future performance, it is the act of future performance, not the promise, that operates in satisfaction. And halfway down on page 644, having identified certain general principles applying to accord and satisfaction, it says, an accord with mutual promises to perform is good, though the thing be not performed at the time of action, for the party has a remedy to compel the performance, that is to say, a cross-action on the contract of the court. And the purpose of opening that passage is to demonstrate that the first principle upon which we rely is that in this case, it was a very important part of the bargain entered into by the parties, which we say was a strong plank or pillar of the very consideration underlying the agreement, and that the construction that is contended for by the defendant of Article 14 in effect amounts to an attack on the consideration underlying the agreement. We say in respect of this particular clause 13, representing a strong and substantial part of the overall bargain, if you don't have a remedy, you are in effect taking away the consideration, you're taking away the quid pro quo for an accord and satisfaction. which cannot be right, at least, at the very least, on the basis of the, again, first principles of construction. It would be inherently improbable that the parties would have agreed on such a course. And again, my Lord, you very likely emphasised Article 17 and its connection to Article 17, and how the consequence of the construction contended for by the defendant is that by suing, which is the ordinary remedy available for a future performance in the court of such action, you would then lose the entire benefit. That is harsh, that is extreme, and again, inherently improbable. So, my Lord, if I could refer you then to the next authority in the book. This is the Reed-Perkins judgment, which is the leading statement of Master of the Rolls Lindley in case.
So which divider you mean?
Divider 14.
Yeah.
This was a case against the background of certain covenants containing releases. It wasn't a release clause as such, but there were covenants you'll find that explained at the bottom of 187 in the first instance judgment of Judge Moore. I won't bring you to that. But the general principle, an important one, is set out at page 190 of the Master of the World's judgment. Beginning just in the first paragraph, he says, the release contained in the deed, although couched in very general terms, must, if possible, be so construed as to not defeat the object and purpose of the deed of which it forms part. The recitals and first witness in part show that the release can't be rationally construed as extending to all of the estate, including the asset assigned to the plaintiff. Again, the claims and demands from which the estate is released cannot be rationally construed as all claims and demands in respect of the covenants. Though there are covenants contained in the agreement, and just as here we say there is an contractual obligation, Article 13, contained in the agreement, that as a matter of inherent improbability, but also as a matter of construction, ought to be given effect which allows for a remedy. And that principle, that you'll see it again elaborated on the following paragraph, in so construing the release, the court is not departing from well-settled principles applicable to the construction of documents. General words of the release are always controlled by the cycles of context, which show that unless the general words are restricted, the object and purpose of the document in which they occur must not necessarily be frustrated. And I think you have seen from our submission that a broad, multiple argument we have raised in this case is that it would, in effect, nullify Article 13 to deprive the claimant of a remedy for a breach of the agreement itself. We say that on those principles, the object, a very strong underpinning object of the agreement, negotiated in a hard-fought way, as one of the key things in the agreement, must have a remedy for its breach. And I won't open the authorities that refer to Reed-Perkins. You'll see from our submission of paragraph 47 that in the Court of Appeal judgment, which is now the correct judgment at tab 15, the Court of Appeal judgment in BCCI and Ali, at paragraph 47, we referred to the three passages from the judgments of Vice Chancellor Scott, Lord Justice Chadwick, and Lord Justice Buxton in the Court of Appeal judgment, in which they refer with approval as to the principle, not just in this context, but these are cases involving a release, that a release clause, even though couched in general terms, should not be capable of frustrating purpose of the agreement. And we say we should be allowed to make that case following disclosure and following the hearing of the parties, including on cross.
Yeah.
Your Honour, I have, excuse me, I have 6 points in reply in relation to the exercise of the bonus discretion, and 1 point in reply in relation to the unfair term. As to my 6 points in reply on the exercise of discretion, first, the claimant has conceded, as I understand it, that there are defects in the pleaded case. 2, if one looks at the pleaded case, one can see that there's a reliance upon the grievance process. That's at paragraph 26 to 37. And there's been nothing said by my learned friend which goes behind my submission that that grievance process is after the event being the decision to award the bonus, or not as the case may be. The express terms and a breach thereof, Peter, paragraph 42 to 44, it's now said that that is actually a breach of an implied
Before we leave grievance, I think it's common, it would be accepted that the grievance procedure and any complaints about it are in relation to events which occurred after the decision not to award a bonus.
Yes.
I think what is being said by this argument is that the inadequacy, that's not quite the right phrase, the shortfall from proper procedure as demonstrated in the grievance procedure is indicative of an employer who does not take trouble in considering applications for a bonus, and indeed indicative, I think she would go so far as to say, that the inability to justify the conclusion that had been reached encouraged a poor process. That the implication is that the employer recognises that there were serious deficiencies in the conclusion on the bonus. I think that's how she puts it. That's not quite in that phraseology.
I was going to deal with this under my third point. What we're really left with is a series of new allegations. The first is that Mr. Winters invented the reasons for the D value rating. Then it said that he failed to take into account reasonable considerations. That's the second in the Wednesbury. There's thirdly been an illusion shot practice, but I think that's not really been developed. And fourthly it said, and I think this is really the giveaway, it said that it's not only a decision that was irrational, it's also a decision that was unreasonable.
Well, unreasonable in the Wednesbury sense, yes.
Yes, and that is a wholly different claim to the claim of irrationality that's been pursued to date on the pleaded claim.
No, I think she's using reasonable in a Wednesbury sense. I agree it's slightly old-fashioned, but indeed that's what the decision of Brigams is all about.
Well, if one then goes to the substance of the allegations, she says there's no evidence to prove that Mr. Winters believed in the decision, and that there's been no proper grievance process and other processes.
Yeah.
And we say what that really amounts to is an attempt to go behind the decision and to see whether or not it was reasonable, not in the Wednesbury sense, but in the negligent sense.
Well, that may be what she's saying. I'm not sure she is. But the proposition seems to be as follows. One, the counter to the point that is made by Mr. Papadopoulos, that his registration, if that's the right phrase, as 3B in 2014 was strangely changed to 3D in 2015, is not explained, she says, by absence of familiarity of Mr. Papadopoulos by Mr. Winters, because he had known about him for some considerable time. Now, I got rather lost on the dates here. I think it's your case that it's perfectly plain that Mr. Winters was only aware of Mr. Papadopoulos for about 4 months in the run-up to his decision.
Yes.
Yeah. The allocation of 3B, maybe it's 2B, doesn't matter, for 2014 is for the entire year, as I understand it. So
yes.
how is Mr. Winters able to make an allocation for an entire year if he's only known the man for 4 months after that year is actually ended?
Well, I believe what happened is that Mr. Papadopoulos' manager, Mr. Shankar, left prior to the formal decision being made in March 2015.
Okay. All right. Well, that may well be right.
But our case is that everything prior to the 2015 mid-year decision
Right.
is just Mr. Winters adopting
Yeah,
a prior rating.
and people can change, facts can change.
Yes.
Now, anyway, more substantively, she says that the reasons advanced by the bank for refusing the bonus seem to change rather regularly. The only common theme, I think is accepted, was the stylistic complaint.
Yes.
The other complaints, Bahrain complaint, is it ACCA? ACCA, and maybe one or two others. They came and they went. Now, what do you say about that?
Two things. First of all, Mr. Winters in his decision email of the 17th of March makes it clear that while there are these other issues ongoing and that was still being investigated, he did not feel he could take it into account for the purpose of his decision.
Right.
He only takes into account the management issues.
Well, where is the evidence for that? There is no witness statement from Mr. Winters.
I think you've had your chance, Mr.
I apologise, I'll sit down.
Yeah.
Your Honour, I've taken it to you before, but if you look at that email, the first section sets out other concerns, and the second
I
section
read the
comes
email
on
for
to-
myself. I'm just wanting some observation on the proposition.
Well, that's the observation, the first one. The second one is the prior reasons allegedly given by Mr. Madapra and others. We say there is a gap, evidentially, between that and the reasons given by the decision maker. As set out in Braganza, what the court needs to do is look at the mental processes of the decision maker. And all of the emails we've gone to, the grievance process, the price settlement negotiations, the reasons given by Mr. Madapra, none of those relate to Mr. Winters.
Thank you.
That was my third point. My fourth point, Your Honour, is in relation to the evidence.
Yeah.
What this really amounts to, we say, it's set out in paragraph 75D of my learned friend Skeleton argument, is if we get to trial and we have the full disclosure process and there's an opportunity for her and Mr. Dillon to cross-examine the bank's witnesses, something may come up which comes close to proving that the decision to give a D rating by Mr. Winters was invented. And I refer you specifically to their skeleton at 75D, and they've repeated it in their submissions today.
Yeah.
The fifth point is that Article 57 has been alluded to on a number of occasions, giving rise to an obligation, an implied obligation. It seems to be an implication of law that Clause 13 is subject to rationality and reasonableness consideration. That's effectively a duty of care. That's how I understood it. And we say that's not pleaded. That's not the basis on which it's been put. It's been put as an ordinary matter of construction, implying a good faith obligation. And so those submissions are new as of today. My final point relates to UCTA. May I take you back to law number 6? It's been suggested that we've got this the wrong way round. The starting point is clause or article 38, it's on page 14. It says, where a party seeks to exclude or restrict a liability, that's under 38(2)(a, he has to prove that it's reasonable. That's the last line, last stanza of 38(2).
So where are you reading?
Page 14,
Yeah.
article 38.
Yeah.
38(1) is the requirement that it's standard terms of business.
Yeah.
38(2), so that when a party, in this case it's a claimant, in this case the bank, seeks to exclude or restrict a liability, in this case through clause 17 of the settlement agreement, we have to satisfy the requirement of reasonableness. That's the last line. And then when one gets to what reasonableness means, one goes to Article 40. So, my learned friend can't have it both ways. If they are seeking to rely upon this law, they have to invoke Article 38. Not Article 40. Article 40 just explains what reasonableness means. Article 38 is a substantive provision. 38(1) provides there has to be standard terms of business, and for reasons I've already set out, that's not satisfied.
Yeah. Okay.
Your Honour, one final point. We say the claim has moved on in terms of the way it's put in today's hearing. And we'd ask Your Honour respectfully to cast a critical eye over, in particular, paragraphs 26 to 37, the grievance process, paragraph 42 to 44, the express terms, and paragraph 45(1) to 45(2), which is the implied term allegation, which relates to the grievance process and the negotiation of the settlement agreement. And we said those are the provisions of the claim that fall to be struck out or disposed of on an immediate basis. If you're with me on the express term and the implied term, the claim effectively falls away. But in any event, there are serious deficiencies in the pleading that have to be dealt with, even if you're against me on my substantive application. I'm grateful. I can assist you any further.
Thank you. Yes?
My Lord, can I address you on one point that was perhaps mischaracterised in my letter of submission? I didn't concede that the pleading was defective. What I said was, if the criticism is that the pleading is defective, then that's not a ground for allowing the application. And in any event, what I say is that paragraphs 42 and 43 read together, one can see where we refer to in 43 unreasonableness, capricious and in bad faith, and obviously we don't refer to fair dealing, but where unreasonableness and bad faith is a direct reference to Article 57 to D, and therefore we say that the case hasn't changed, it's just the defendant's understanding of the case isn't or doesn't accord with the pleading.
Okay.
I'll leave it there.
Very much. I will take time to consider my judgment. There are written judgment which will be made available for handout in due course. I'm making no promises as to when it's going to be available. But I hope you won't be too long. Thank you very much.
My Lord, just before you rise, both parties have put forward cost schedules, and so you ought to have.
I received a schedule of costs from the defendants,
There was
not from the claimants. Thank you very much.
My Lord, would you like us to make submissions on costs, or should we just await your judgment?
First of all, is it agreed that I should deal with the issue of costs as part of my judgment, in the sense of allocation of costs?
My Lord, it rather depends on your judgment. So, for instance, if the defendant succeeds on their application, then I think that, I don't have a copy, but they've claimed for all their costs from the inception of the claim, if I'm right. Now, there's 2 points that I'd make there. Number one, they shouldn't get the cost of their own, the whole claim, only the cost of the application. But if I am wrong in that, because they've been successful, then I would see that this matter goes...
If the claim is struck out, effectively, i.e. struck out or immediate judgment on the grounds that has no reasonable prospect of success, then the defendant should get the costs of that.
And I see that, my Lord, which is why I don't spend too much time on it. However, we would ask that the cost, there's a detailed assessment of costs rather than a summary assessment.
Yes. At these level of costs, I'm not sure I would embark upon summary assessment anyway.
Well, my Lord, the defendant has claimed in the region of $227,000.
You see that? Well, I mean, there may be some points on quantum, of course.
Yes.
But I'm not sure what you're asking me to do.
Well, Your Honour, it seems to me that it's sensible to await the outcome of your judgment. There are a number of potential permutations,
Right.
and one could only really deal with that.
There may be various issues in which people succeed or lose. There may be various points to be made on the allocation of cost, and there may be other points on quantum. So let's leave it for the moment. Thank you very much.
All rise.
Thank you. Are you going back today? Marathon, wasn't it? It just won't stop. Yeah. Yeah, because actually, if
Yeah.
yeah. Yeah. Yeah. What's that? Royal Shield. Rob's going. Oh, I can't take any thanks for it. Sorry, I couldn't miss that, Karen. Huh?
Oh, well.
Is he going to leave? Does he head to...
He's coming right for shopping. Yeah, he's coming there.
I mean, I need that festival, but I just thought I'd run it anyway. You know, the costs.
Yeah.
I just thought I'd just...
So that's what they open it for everything.
Yeah, exactly.
No, but I said there is my something like just try some stories.
Yeah. Cool. So much.
Oh, okay.
So sooner we have it, the quicker they start. And also we need to balance out these on the extra pieces of work. You know?
Even there,
Was there big one? Why didn't you check your lease? Have you checked with her? Said 50k? Yeah. Yeah, anyways. Yeah, and some of it's for that.